Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to class number 9 of our 2022 Virtual HOA Condo Academy. We're in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Thanks so much for joining us here today. We have a really great class planned for you this morning. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with HOAs and condominiums as their legal counsel for over 25 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Before we dive into the topics of today's seminar, I want to definitely reach out to you and find out who's in our audience today. So I can tailor the information best to our presentation today. So we're going to be talking about rental restrictions, which is going to cover short-term rentals, how to best handle rentals in your communities, whether they're long or short-term, some statutory law that pertains to associations, and a lot of other really good things that pertain to just how rentals are managed in your association. So got a poll here for you this morning. It's already up on your screen. If you're joining us on Facebook Live, make sure that you enter in the comments section your answer to these 2 poll questions. So the 2 questions are, number 1, in which city do you reside? It's important we're asking that just so that we can get feedback to the respective cities that we partner with, who's here from that city. And then the second question is, what is your current role with the association, if you have one? So are you a board member? Are you a manager? Are you a homeowner? Or are you other? And we're going to dive kind of like right into the agenda this morning, so we have a lot to cover. And then we're going to give you the poll results here in just a minute. So what's on today's agenda? While we wait for the poll results to come in, let's talk about today's seminar and our topic, rental restrictions. I mean, you can barely open the newspaper, or if you're reading it online, checking it out online, without hearing about some story pertaining to rental properties, whether it's short-term rental properties, maybe it's problems. Just issues in general with rentals are something that is becoming probably one of the top 5 things that our firm is being asked for advice on. So it's a really hot topic in Arizona right now. It's really important for us to delve into today. What can the board do? What are the things that we can do under the law to find out information about renters? What types of amendments can we pass in our CC&Rs for rental restrictions? And what type of regulations can there be so that people are following, so that short-term renters and owners who are landlords are following the association's documents? As always, we're going to have a free Q&A at the end of the class today, where I'm going to answer every question that's submitted. We encourage you to submit your questions via the chat box or Zoom or the comment section on Facebook Live. But we do ask that we limit it to 1 question per person and try to be as specific as possible, as it's really hard to do follow-up questions while we're teaching a live virtual seminar like this to find out more information about the question. So try to be really specific and concise so that I'm sure to be able to answer your question today. Also, as part of this class, we're going to talk a little bit about the 5 new laws that are going to be going into effect here very soon on September 24th. And so this will be kind of like your last primer on the new legislation before it goes into effect here later this week. So let's go back and see who's here with us today. The results of our poll are in. In terms of which city you reside in, we have representation today from Chandler, 7%, Glendale, 4%, Goodyear, 2%, Mesa, 9%, Peoria, 7%, Phoenix, 30%. Wow, that's huge. Scottsdale, 33%, also huge. Surprise, 4%, and Tempe, 4%. So we have really a great representation of all the different cities throughout the Valley of the Sun. So wonderful. Thanks for being here with us today. Okay, next question. What is your current role in the association? 52% of you here today are board members. 11% are managers, and 30% are interested homeowners, 7% at the tail end as other. So while we have a really great representation, the entire Valley this morning on our virtual seminar, and we also have almost, a pretty even mix of board members and homeowners. And that's great because we want to, give a presentation that is going to be helpful and useful to the board as they're navigating rental issues and also homeowners. Some of the homeowners here today may have a neighbor that is rental property and they're not happy about that. Or maybe one of the homeowners is actually renting their property and they want to know how they can best work with the association. So thanks everybody for being here today. Great information and feedback as we start the presentation. Okay, so let's get into the nitty gritty on rentals and rental restrictions and what associations can do. First off, for those of you who may not be familiar with our firm, we have about 60 different cheat sheets. And these cheat sheets are on different topics pertaining to HOA and condo law. Basically, how we came up with the 60 different topics, 60 plus topics, is we take a question or an issue that we're hearing time and time again, questions about whether it's reserve studies or how to have a successful annual meeting or what does the open meeting law in Arizona say. We have a specific cheat sheet, which is a deep dive on rental properties that we're going to be sharing with you on Zoom and Facebook Live today. So after the presentation today, take a quick peek at this cheat sheet. It has great information. You can also share it with your board or with other homeowners if they're interested. It's just a great quick read, about 4 to 5 minutes on everything you need to know about rental properties and associations. We're going to be sharing that with you shortly if we haven't already. And you can also find all of our cheat sheets, including this one, on our website at mulcahylawfirm.com. Okay, so let's start out with the history of rentals and short-term rentals in Arizona. I think we can all agree that over the past few years, there has been an enormous increase in the number of rental properties in Arizona. And this includes short-term vacation rentals like VRBO or HOA or Airbnb. At least once or twice a week, I'm contacted by a board regarding a problem with a difficult tenant who's maybe not following the association's documents or maybe who they think might be violating the law or misbehaving on association property. And this is a very common question that we're getting right now. It's important to remember, just as a baseline starting point, that the CC&Rs are a contract between the association and an owner. And it's just like any other contract that is established in business or in the law. And so there are respective responsibilities and obligations and expectations placed into the contract. And that being said, it's really important for each association to review your CC&Rs and figure out what they say regarding rental properties. Like, can an association owner who wants to rent a property, can they rent it? For how long? Are there any sort of restrictions on that particular rental? And so just important to remember, check the contract. That's kind of a first point we're going to talk about here today. So everybody, to get baseline knowledge of what's in your documents about rental properties, you need to check your CC&Rs. Next, we also need to be aware of the fact that Arizona law has some statutory law has some restrictions in it about rental properties in a condominium or planned community. And we're going to be talking about those different restrictions here today during this presentation. And actually, one piece of the new legislation or one of the bills deals specifically with short-term rentals. And like I said, that bill's going to be going into effect this weekend. And so it's really great timing that we're having this class. So important to look at the CC&Rs, important to know and understand what the law is in Arizona, specifically Arizona statutory law regarding the rights of owners to rent and also what the association can ask for from a landlord owner. Also important to think about the fact that under Arizona law, if there is going to be some sort of a restriction on rentals in an HOA or a condominium, it really needs to be in the contract of the CC&Rs pursuant to statutory law. So that just kind of ties together the contract and the law. If you want to, rent your property, or you want to have restrictions on renting properties, such as minimum time periods to rent or absolute prohibition of rentals, it really needs to be in your association's CC&Rs. Let's switch over and talk a little bit about one of the most common questions that I get from boards. We know somebody has a rental property in our community, and we want to ask for more information from the landlord owner about the rental property. So it's important for you to know that Arizona law specifically tells us as associations what we can ask for from a landlord owner, and it's very limited. So a common question that I get from boards is, can we have a copy of their lease between the landlord owner and the tenant? Arizona law does not allow us to mandate that they provide us a copy of the lease. There are some things that we can ask for, and that would be pursuant to Arizona law. This applies to condominiums and planned communities. So here are the three things that can ask for as an association from a landlord owner. Number one, the name and contact information for any adults who are occupying the unit. You can have a form maybe that has a listing for the owner, landlord, plus the name and contact information for adults in the unit or lot. We also, as an association, number two, can ask for the time period of the lease, including the beginning and ending dates of the tenancy. So when the lease starts and when the lease ends. And the third, we can ask for a description of the license plate numbers, a description of the vehicle for the tenant, and the license plate numbers for the tenant's vehicles. So those are really the only three things we can ask for. And let's face it, that's not a lot of info, right? So it's just the name, contact information for the adults in the unit, time period of the lease, including beginning and ending dates, and a description of the license plate number and vehicle of the tenant. If the association's an age-restricted community, we have an additional thing that we can ask for. Now, what do I mean by age-restricted community? Any community that's designated as a 55 and over community under the Fair Housing Act, you also can ask as a fourth category of information. You can ask for a government-issued identification for the tenant with a photograph of the tenant on it and confirmation that the tenant meets the minimum age restriction for the association's CC&Rs, which is like 55 or over. Now, why can we ask for that? Because in order to be certified as a 55 and over community, we have to have at least 80% of the occupants in the unit or lot being age 55 or over. And that can be satisfied by just one occupant occupying the unit or lot being age 55. So if we have a tenant coming in, at least one of those tenants in a 55 and over community must be age 55 or over if your association is designated as a 55 and over community. So bottom line on that, not much we can ask for in terms of details regarding a tenant from the landlord owner. And again, we cannot under the law ask for a copy of the lease. Now, the tenant or the landlord can gratuitously give that to the board. But in my experience, they are hesitant to do that and they don't want to usually do that. Okay, can we charge any fees for registering a tenant or having a new tenant move into the association? Yes, there is a minimal fee under the law that the association can charge the owner for each new tenant. And that fee is no more than $25. And again, that fee can be charged for any new tenant, but it can't be charged if the same tenant is carrying over for an additional time period, an extension of lease, or they extend their lease type of thing. So it's one-time fee per tenant. And if the association can request that information from the landlord owner, if the landlord owner doesn't provide that information, the association can charge a $15 late fee if the landlord owner does not pay within 15 days after the postmarked request for this $25 fee and the information regarding the tenant. So bottom line, quick recap, there's three categories of information that we can ask for from a landlord owner regarding a tenant. There's a fourth category if you're 55 and over community. We can charge a $25 fee per tenant, the kind of information that we can request, and we request the payment of $25 fee per tenant. And 15 days passes and they haven't paid it, we can add on a $15 late charge. Now, there are a couple things that we are prohibited from doing under Arizona statutory law regarding tenants in an HOA or condo. So as I said previously, we can't require the tenant's rental application or a copy of the tenant's lease with the landlord owner. What are some other interesting aspects of the law pertaining to rental properties and HOAs and condos in Arizona? So something that's really kind of fascinating is as part of this new legislation kind of all went into effect back in 2016, where they really highly structured how much information we can request from the landlord owner. So as part of this new law back in 1996, they added a section that said that if you're a landlord owner or if you're an owner who doesn't reside on the property, the association can't prohibit or restrict you from serving on the board. And that's really kind of interesting because typically, and I'm in favor of this. I think everybody should have an opportunity to serve on their board, whether you live on site or whether you're a landlord or maybe using the property that is more of an enterprise, a business enterprise. We can't prohibit that off-site owner from serving on the board. And that's right in statute. Interestingly, though, an owner may use a crime-free addendum as part of a lease agreement. And this section does not prohibit the owner's use of a crime-free addendum. So for somebody who may be familiar with the crime-free addendums that may be attached to leases, you may want to Google it to find out more information if you're a landlord listening in on this today. Basically, it's just the landlord mandates that, the tenant not engage in any criminal activity, and there may be some other restrictions that they write into the crime-free lease addendum, like certain types of people that may have a felony may not be eligible to rent, etc. This law that we're talking about here today does not impact a landlord to ask for a crime-free addendum to be filled out by their tenant. So it's kind of important because there are some landlord owners that want to find out as much information as they can about the tenants, and this law doesn't prohibit them from doing that. Another really interesting tidbit of this law, and I hate to geek out on you on this, but this is so fascinating, is that the association can put something in their documents, meaning the CC&Rs, that restricts residency of persons who are required to be registered pursuant to Section 133821 of the Arizona Revised Statutes, who are classified as a level 2 or 3 sex offender. So apparently this 2016 law gave green light to associations who want to put in a provision in their CC&Rs that would limit or restrict registered sex offenders that are level 2 or level 3 sex offenders from living in the community or owning in the community. So either as a tenant or as an owner. It's interesting that this is put in this retro restriction legislation from 2016. I'm not even sure it's frankly enforceable. I think that might be a case that could go to the Supreme Court of the United States trying to prohibit somebody that is a level 2 or 3 sex offender from living in an association. But regardless, they added it, and it says that we can lawfully enforce any provision in our CC&Rs that prohibits level 2 or 3 sex offenders from living in the association. Now, I don't have a lot of clients since 2016 that have run out there, passed an amendment to their CC&Rs limiting level 2 or 3 sex offenders. I am aware of a couple of associations in Arizona that have implemented this section, and it has not been challenged. So it's just kind of an interesting part of the law that I wanted to talk about with you today. Another important part of the law is the question of fines. So if you have a tenant that, and we're going to talk about this a little more in a minute, but if you have a tenant who is not following the association's documents, we can fine the owner for the tenant's behavior. But we cannot fine the owner for not providing the information that, the statute says we can get from the owner regarding the tenant. So we can charge the $25 registration fee. And if they don't pay it within 15 days, we can charge a $15 late fee. But we cannot ding a landlord owner for not giving us this information under the statute with a larger fine amount. So that's really important that we talk about. Also, it's important to note that we cannot charge a parking fee if the same fee is not being charged to an owner that's occupying their lot. So you have to have same fees would be charged to owners and tenants in the association. So sometimes you'll see an association say, well, we want to charge the tenants more for, access to the pool or to be able to use the gym at the association. And the tenant can't do that because the owner has the right to delegate the use of the common areas to their tenant. And we can't make an add-on special charge that's discriminatory against the tenants. Okay, a couple other points that I want to mention that are just kind of interesting tidbits is, I don't know if you know this, but under the law that was passed in 2016, a landlord can be held criminally responsible for not abating criminal activity within a HOA or a condo. And so if you're one of these associations that might be listening in today, or maybe you're a neighbor of a property where you think there's a short-term rental and you think there may be criminal activity going on there, it's important to note that under the law, the landlord could be responsible for any criminal behavior and could be prosecuted for that. I've only seen one case since 2016 where this has actually happened, but I am aware of one case in Maricopa County where a landlord, it was actually, a slumlord, so to speak, had, was renting to a lot of drug houses, and one particular one had escalated into really a mess, and there was a drive-by shooting. And the county prosecutor did bring charges against the landlord, and there was a trial. And one of my clients, the board, was asked to testify against the landlord. And there were repercussions against this landlord. I believe he was convicted, and it's on his record. It wasn't a felony or anything, but it was a misdemeanor. It's notable because that can happen. So why is that important? If you're an association that has one of these bad tenants, so to speak, that's violating the law, maybe drug activity, criminal activity, make sure you are documenting it by contacting the police when you have evidence that is credible. Make sure that you are visiting your local police precinct to ask them to investigate, drive by this property. Make sure that you're notifying the association's board so that they can consult with their attorney to talk about what sort of legal remedies we may have as an association to crack down on the landlord to curb the tenant's bad behavior. Okay, let's switch gears and talk a little bit about what are some responsibilities of landlords. There's a couple new laws that are going to apply to some different things that landlord owners and associations are going to have to comply with. And there also are some, county laws that are in taxes that are also the landlords are going to have to comply with. So let's just kind of touch base on those quickly. So first things first, this law has been on the books. Landlords must register their rental properties. So this is pursuant to Arizona Revised Section 33-1902. An owner of a residential property located in Arizona is required to file a notification form with the county where the residential property is located. The notification form has information that needs to be filled out, and that information is the property owner's name, address, a telephone number, the street address of the residential property, and the year the property was built. And owners who don't comply with this requirement to register their rental properties after notification and a 10-day grace period are subject to a civil penalty of $1,000 plus $100 per month for every month the owner is not in compliance with this notification requirement. So how does this come into play? Of course, landlords need to register their rental properties with the county where the residential property is located. How do we know if the landlord has done this? The best thing that you can do is go to the county assessor's website. If you're in Maricopa County, which probably most of us on this call are today, you could just Google Maricopa County Assessor's Office. And then you can do a search by the address of the property. So wherever the rental property, the address of that rental property, you just type that in. And you click on the net parcel number for that property. And you will be able to see right away if the property is registered as a rental property or not. And why does the county do this? Well, first of all, they want to have this information at their fingertips. Number one, to contact the owner. Number two, they want the taxes on each rental. And so they're very in favor of making sure that this law is being complied with by all landlord owners. And so basically what comes into play is maybe an association has a rental property. And I have some associations actually that keep a list of rental properties. And they check every year to see if the landlord hasn't registered their rental property with the county by going to the county assessor's office, like I said, typing in the address of the property. And then there's a code that indicates whether it's rental property or not. You'll see it right on the screen when the property address is clicked on. You can file and notify the county that a property is being used as a rental property if it's not registered as a rental property. And the county will definitely investigate that and pursue that owner further. So that's kind of an important thing to remember. So if you're an owner or landlord that's on this call today, you must register your rental property where the county where the residential property is located. If you're an HOA board or a condo board and you want to check to see if a property has been registered as a rental property because you have knowledge that it's being rented out, you can go to the assessor's office for the county that you live in, type in the address and find out if it is registered as a rental property or not. If it's not, you can tattle on them and the county will investigate and pursue them. Okay, let's talk a little bit about some other laws that have impacted associations recently. So we talked a lot about the 2016 legislative session, and this history is really important for you to understand how this short-term rental situation has evolved in Arizona. So prior to 2016, how rentals worked in different cities, towns, municipalities, and counties was that the cities had in place ordinances and restrictions and zoning, which limited where transient or nightly rentals could be housed. And so prior to 2016, in most cities, towns, counties, and municipalities, you had to be zoned to be like a hotel or transient rental in order to do nightly rentals. And most cities, towns, the county, most had a 30-day minimum rental period in residential neighborhoods. And so prior to 2016, associations didn't have to worry about nightly rentals because it was all taken care of by the structure of the different city, towns, county, that the association property was located. They had these restrictions in place, so they were enforcing them. And as an association, we didn't have to worry about nightly hotel type hotels. But the whole game changed. And really, in 2016, the legislature passed some new legislation, really changed things up for associations. And I think it was a result, just looking back on it now, this was just at the point where Airbnb and these short-term rental companies were just really starting to become known and more popular. And I think what happened is the lobbyists for these different companies lobbied to have the law changed so that these short-term zoning and residential restrictions could be lifted from HOAs and condos so that you could do nightly rentals in these different areas and you didn't have to worry about the city or town or county zoning. So what did they do in 2016? Our legislature took away the ability or severely limited the ability of a city, town, or county from prohibiting or restricting the use of or regulation of vacation rentals or short-term rental properties. Basically, any of those zoning requirements regarding, this is a residential property, you have to have a minimum 30 days, which may have been codified, the ordinances with the city, town, or county. Those were all lifted when the statute went into effect in 2016. And basically, the cities, towns, counties, regulate these short-term nightly rentals anymore through ordinances or zoning. What did that mean for associations? Well, they passed a law, Arizona legislature, that said, well, if associations want to rent, if they want to restrict rentals or they want to prohibit rentals, this can be done, but you need to put it in your CCNRs. So really, this was a game changer for associations on rentals because it wasn't really on our radar that we needed to have a minimum time period for rentals in an association because the city already took care of that for us. It had to be 30 days in those cities. And it was kind of a newer thing that was evolving with this short-term rental thing. We weren't seeing these nightly rentals popping up in associations. Well, so 2016, game changer for sure for associations. Legislature says to associations, condos, and HOAs, if you want to put into place short-term rental restrictions or minimum rental periods, such as You have to have 60-day minimum rental in our ABC HOA association. It has to be in the CC&Rs. Now, I think what happened here is that the legislature isn't fully grasping how difficult it is to amend the CC&Rs for most associations. A lot of associations have a very high percentage of owner approval that's needed to amend the association's documents. So we see associations with amendment provisions that could be as high as 90% approval of the members. It could be as low as 67% if you're a condo, maybe even as low as 51% if you're a planned community. Bottom line is, it's difficult to get people to vote for these amendments, and it's difficult to get the requisite percentage. So by the legislature saying, oh, well, if you want this, just put it into your CC&Rs. Well, in theory, yes, I get that. But in practical, reality of this world, it's really difficult to get owners to vote on anything. We've even had situations in an association where we are voting to give money back to association owners, and we can't even get the requisite percentage to do that. So if that isn't telling, I don't know what is. Basically, this just really put associations in a pickle because starting in 2016, they either needed to get the requisite approval of the membership to amend their CC&Rs to put in place minimum rental periods or pivot rentals, or they were stuck allowing nightly rentals. It's kind of like paralysis analysis by paralysis or paralysis by analysis, whatever the term is on that. And basically, while they were waiting to see what happened and how this law may affect them, what was happening in our economy, right? 2016 to 2022, what did we see? We saw people buying up properties and people moving to Arizona, not only from Wisconsin and Illinois and Michigan and Minnesota, but from California and other states where they were leaving because of the high taxes. And so we saw a huge influx of new residents coming to Arizona, snapping up properties, and also a lot of investors. And with that change in ownership, we started to see a change in the demographics of the association. And why is that important? It's important because associations now maybe went from having 1 or 2 short-term rental properties to 20, 30, 40, 50 in an association. And as time passed, we started to see more and more rental properties in each community. And why is that important? Because when the association started to see the problems that were associated with rental properties, and they kind of got their act together and decided, hey, we should pass an amendment to our CC&Rs, maybe there's 100 owners in the association. And now we have 35% of those owners who are investors or who are renting their property. And they're not going to vote yes to amend the CC&Rs to limit or restrict the time period for rentals. So now associations are kind of stuck because they can't get the votes to amend the CC&Rs to implement minimum rental periods or prohibit rentals altogether. Now, that's not every association, but the trend that we've seen. And there are ways around that. Of course, we can grandfather all of the existing owners. We can grandfather the people that are currently renting as long as they're owners. There's a couple workarounds on that or pulls, but it does make it more difficult. So it's important. It's important that we talk about it and mention it. So 2016, like I said, game changer. The law changed. We saw a huge influx of investors. In the summer of 2019, 2018-19, we started to see a lot of grumblings in the newspaper. Residents of Sedona were very upset about the number of short-term rentals that were coming into their city. And there's a very high percentage of short-term rentals in that particular city. And frankly, it was starting to become more prevalent everywhere. If you look at the recent statistics for Scottsdale, it's 4,000 plus short-term rentals in Scottsdale alone. These are some big numbers. So in 2019, the legislature kind of started to figure out that, hey, wait a minute here, this is becoming a problem that we're seeing in the newspaper. People are complaining about this. And so in 2019, the legislature passed a law, just kind of like try to correct this with just the minimalist possible effort. So they passed a law that expanded upon the areas where a city, town, or county could restrict short-term rentals. And that could include a prohibition against short-term rentals being used for non-residential purposes, including for special events or for retail, restaurant, banquet space, event center, or other similar use. Basically what they were saying is, okay, the town now, city or town or county can restrict short-term rentals in just this little way. And that is, like, we can say, you can't use a short-term rental for non-residential purposes. So what was happening is, these big, beautiful homes in the valley were being converted into, Super Bowl party central, and they were bringing in DJs and all kinds of crazy stuff. Or maybe they're converting it into a banquet space for wedding receptions. And, we've got 100 cars clogging up the streets of a HOA. And so this was just kind of like a little fine tuning. They were dipping their toe in the water, the legislature, to, okay, we're going to just crack down just a little bit on these short-term rentals in 2019. So you can't use short-term rentals for non-residential purposes like retail, restaurant, banquet space, event centers, or similar use. Okay, well, that's helpful. But it didn't address the big problems. And really what we started to see in 2019 was it got the governor's attention. So Governor Ducey started talking about this in the summer of 2019. And especially one time was really kind of stuck in my mind was in the summer of 2019, Governor Ducey was in Sedona, and he actually made a statement about it after a meeting up there. And basically the gist of it is that I understand this is a problem, and the legislature needs to go back to the drawing board and figure out a way to correct this problem so that we do have some regulation of short-term rentals, because it just basically become anything goes, right? Unless passing an amendment to your CCNRs. And so, then what happened? And of course, the next legislative session was pandemic year, 2020. And that was a skinny legislative year. We had very few bills passed other than the budget. In fact, there were no HOA bills that year. Last year was still what I would call in the 2021 legislature a recovery year for the legislature. And, we didn't have anything that was especially notable that would help associations that are dealing with a large influx of short-term rentals in their community. Well, let's fast forward to this year. This year, finally, 2022, the legislature decided to pass a law that's going to go into effect this weekend that places some additional burdens on the landlord owner to provide information to cities. So let's talk a little bit about that law, because that's definitely going to be a game changer for associations, HOAs, and condominiums that are managing difficult situations, short-term rentals. Let's talk a little bit about that. It's Senate Bill 1168. It was signed into law. It was one of the last bills that was signed into law this year. On July 6, 2022, it'll go into effect this weekend. And again, this law applies to planned communities and condominiums. And basically, it sets forth the ways that cities and towns may regulate vacation or short-term rentals. And so there are a number of different things that landlord owners now must do starting this weekend, September 24th, to register their properties, etc. So let's go through those different requirements that landlord owners have to do and how this can impact positively associations, how we can use this information positively. So number one, the city or town can require the owner to provide emergency contact information for the owner who is responsible for responding to complaints or emergencies. So owner has to provide the city or town with the name and the contact information for an emergency contact on the property. And if they don't do that, there's a penalty of $1,000 against the owner for every 30 days they fail to provide that contact information. So I think the purpose of this first part of the law is let's get the emergency contact. If they don't provide it to us, there's a really stiff penalty per month. Number two, the city or town can regulate that the owner must obtain and maintain a local regulatory permit or a license. And so now the landlord owner, the city or town mandates this, they have to get a permit. or license. Some cities already have this in place. I know I was out in Chandler last week teaching a class, and they already had that on the books. But some cities may, not, and this new law is an opportunity for them to, set up a permitting process. The third requirement that the new legislation has in place is that a city or town may regulate or require that before offering a vacation or short-term rental for rent for the first time, the owner must notify all single-family residential properties adjacent to, directly, and diagonally across the street from the property. So this only applies to the first time that somebody's going to make this property in an HOA or condo a rental property, short-term rental property, or vacation property. They have to go to their neighbors that are adjacent to, directly, and diagonally across the street from the property and let them know, hey, I'm using this now as a vacation or a short-term rental property. The next requirement that the city or town may have is to require the owner of the property to display their permit that the city has given them or license number, if any, on any advertisement for the vacation or short-term rental property the owner maintains. So if they're putting that advertisement in a newspaper, on Facebook, on the internet in some other way, Instagram, on VRBO, or any of these other rental companies online, or the realtors, putting it out on the internet on their behalf, the city or town can require that the permit number or the actual license number be listed on the advertisement. And last but not least, the city or town can require the vacation or rental, short-term rental, to maintain appropriate liability insurance to cover the vacation or short-term rental in the aggregate of at least $500,000, or to advertise and offer each rental to an online lodging marketplace that automatically provides equal or greater coverage. This bill also states that a city or town can deny issuance of a permit or a license for a rental property for any of the following. So if they don't give the information, so let's say that in the past they have failed to give it to us and now they're coming, it could be denied by the city or town. If they don't pay the license fee or the permit fee that the city requires or the town requires, if at the time of the application, the owner has a suspended permit or license for the same vacation or short-term rental, they can say, we're not going to give you, a new permit. If the owner landlord or the applicant on behalf of the owner or landlord gives false information in the application, they can be denied. And lastly, interestingly, if the owner is a registered sex offender or has been convicted of any serious felony in the last 5 years, the city or town may deny issuance, permit, or license for a rental property. Remember, though, that this is a new law, right? And basically, the governor just signed it July 6th, and it doesn't go into effect until this weekend. Now, I don't know how many cities, towns, municipalities, and county have, put into place these restrictions, adopting an ordinance to allow the city or town to have an administrative process for all this. I don't know where every city or town is on this right now. What I would recommend is if you are a board member or if you are a owner landlord who wants to find out more information, think about which city, town, county that you live in and contact them and find out, how do you put into place anything regarding these new restrictions? I'm guessing that the county, they already have a list of the registered rental properties. I'm guessing that they will at some point contact you and tell you the procedure that you follow. Now, if you're a board that has a problem tenant or a problem landlord owner that's not making sure that their tenant's complying with your documents, you also should reach out to your city, town, county and find out what restrictions they have in place in light of this new law and what the procedures are for you to make complaints, to document complaints regarding short-term rentals, and so that you can put into place a procedure going forward for how to best handle difficult short-term rentals and vacation rentals. Okay, I want to make sure that we cover a couple of things that I think are really important on regulating rental. Number one, I just want to emphasize importance of the fact that this problem is evolving and it's going to get much bigger in the future. I mean, I don't know if anybody reads the New York Times, but recently the New York Times had an article and they listed Scottsdale, Arizona as the bachelorette party capital of the United States. And while that's good for revenue and income and dollars coming into our businesses in Scottsdale, that's maybe not something that's going to be good for HOAs and condos that are facing short-term rentals in your community, because we all have known that those parties are going to be a little bit more on the wild side and may cause issues in your community. Some other things to think about is we have the Super Bowl coming up in Arizona, and we really need to have our ducks in a row for associations. Be ready for what's going to happen with that, right? Because whenever there's a Super Bowl or a really large event like the Waste Management Open, the golf tournament in January, we see a lot of traffic in the form of short-term rentals. So we want to be ready for that. So a couple of things that I wanted to talk about are, what can we do if we have a problem with short-term rentals? We need to have a plan in place so that when the issue arises, how do we handle it? So number one, as an association, if you have information that the person is an owner or landlord is renting their property as a short-term rental, you want to check with the county. Talked about the assessor's office to see if it's actually registered as a short-term rental. If it's not, have the right to notify them that you have facts or you believe that this is a short-term rental and ask them to investigate it. Another thing that's important for you to think about is, okay, what are our legal solutions as an association for dealing with rental issues? So number one, if you're having problems in your community and you want to limit them somewhere or prohibit them, remember that an option is to amend your CC&Rs for that purpose. Now, you want to make sure that you're consulting with your legal counsel on this so they can help you with the language and they can strategize with you. Our firm helps many associations through this process, and there's some considerations we have to think about. I want to talk about, there's a new case that was decided recently that's free from Arizona that may limit our ability to pass amendments to our CC&Rs. We want to look at whether you're a condominium or a planned community, because traditionally it's more difficult to implement rental restrictions in a condominium based upon some provisions in the Condominium Act. And we also want to look at the hard numbers in your association, like how many properties are being used as rentals and what's the total ownership in your association? What's the relationship between those two numbers? And come up with a strategy to make sure that we meet your objectives as you're navigating this problem. We have a great cheat sheet on amending CC&Rs on our website, or our cheat sheet tab. It's mulcahylawfirm.com. It's called Amending CC&Rs, a 5-step plan. And actually on the flip side of that sheet is something on rental restrictions and different type of rental restriction amendments you can. So what are some solutions, again, for dealing with the rental issues? Contact the county assessor's office, see if they're listed as a short-term rental. If they're not, handle on them. Amend your CC&Rs to come up with rental restrictions that are going to limit or put minimum time restrictions on or prohibit altogether rentals in your community. Documenting issues with the tenants is humongous. You must do that. And so if you have a neighbor that's complaining about a short-term rental, ask them to put in writing what their concerns are and what happened. And then we need to take that information to the police or contact the police if there's something, criminal activity going on there. Or contact the police if there's a really loud party going on. Send letters, provides information so that the association can send letters to the owner and landlord regarding the bad tenant. Also, we have the ability to fine the owner or landlord for the tenant's behavior. I definitely recommend doing that. We do have to give notice of the violation, and the violation, of course, has to be in the CC&Rs, bylaws, or rules by the tenant, and then an opportunity to be heard. So the landlord owner would, have an opportunity to give a response to the allegations, and then we can determine whether to fine them or not, and the fine has to be reasonable. So fining them is another great option. We have the right to file a lawsuit against the owner for any violations of the CC&Rs. And remember, our contract is with the owner. It's not with the tenant. So any dealing that we have on the bad tenant or the problem tenant is we always interact with the landlord or the landlord's designated agent. We really don't deal directly with the tenant. Can't find the tenant because they're not part of the contract. We can only find the owner. We can only name the owner as a defendant in the lawsuit that we file. One really successful strategy that we've had dealing with difficult or bad tenants is to just have our firm pick up the phone and call the landlord. And we have been really successful in that approach many times. And here's kind of how the conversation goes. It starts out where, I say, "Hi, I'm Beth Mulcahy. I'm the attorney for ABC Association. And the board's asked me to contact you regarding your tenant in blank." And right away, the landlord owner says, "Oh, the board and the neighbor is complaining so much. She's Mrs. Kravitz. They can't even take their trash can out without her snapping pictures of them." And then I usually say something like, "Okay, well, are you at your desk right now? Yeah, your computer. Can I send you some information regarding some things that have been going on in our community related to your tenant? And maybe I'll send a picture of the 25 cars from the raging party and the beer bottles all over the front lawn, and, just the police report showing that the DEA agents just, raided the property last weekend or whatever the issue is." And usually after I start providing the evidence, and that's again why it's really important to have that evidence, the landlord owner starts to change. Their tone starts to change. I'm starting to say, "If you don't do something about this bad tenant, we are going to fine you." After noticing an opportunity to be heard, or maybe there already have been fines that are levied, we're going to file a lawsuit against you. You're going to be responsible to pay my attorney's fees when we prevail in the lawsuit. And this is going to be a really expensive problem for you. Usually at that point, the light goes on, they switch over to our side and they say, "Can I hire you to the tenant?" Of course, we can't do that because it'd be a conflict of interest for me. But what I do give them is the names of eviction attorneys and help them by giving us the documents and the evidence that they need to the bad tenant. I've been doing this a quarter of a century. I cannot believe how long, but it's actually gone by really fast. But I have the best stories of anybody on that, lawyers kind of generally don't have like really good, juicy stories, but I can say that I feel like I've seen everything pretty much. I've seen like homeless encampments that have come to neighborhoods because of a short-term rental. We've seen, like I said, DEA agents storming the property. We've had drive-by shootings. We've had drug houses. We've had people strung out on the lawn, the front lawn, like in very bad health conditions after a raging party. The key thing is we have to document everything and then provide it to the landlord owner. If they don't do what they should do, which is evict the tenant, then provide it to the judge. And the judge will give us the remedies that we need in a lawsuit. So picking up the phone and talking to the landlord owner is a really great suggestion because it kind of cuts to the chase. You're not sending letters and emails and everything. You're just getting right to the bottom of the issue and hopefully getting them to change their mind, do something different. Remember that the best way to get the tenant to comply with the association, CCNR's rules and other requirements is to make it hurt in the landlord's pocket. This is a business for them. They're running this property not to lose money. They want to either break even or make money. And if we start to show them that this tenant is going to, cause them to lose money or legal problems and have to pay legal fees at their side because they're not doing what they're supposed to be doing, trust me, the light will go on and they will start behaving. Of course, our last resort always is to file a lawsuit or to go to the Arizona Department of Real Estate and file a complaint through their administrative law process against the landlord owner. Filing a lawsuit is going to have a lot more teeth because they have remedies that the judge can force the owner to do certain things. The ADRE complaint, they can just issue a ruling that, yes, there's been a violation. There's no enforcement arm of the Office of Administrative Hearings that would be able to help us. Okay, so, that's basically just a really good summary of everything you need to know about rental properties and how to work with them, how to restrict them, how to handle problems. Even this morning, I read an article on AZ Central regarding, a non-fatal shooting at an Airbnb in Scottsdale on September 9th. And so these problems are not going away. So every association should start thinking about their plan and how you're going to handle short-term rentals in your community. Maybe you don't have any problems. That's great if you don't. But if you do, you need to, talk with your lawyer, consult with me if I'm your lawyer about what our strategy is going to be going forward. Because I recently pulled some interesting facts and stats from different articles on AZ Central and the internet. A 2021 study by Northeastern University found that higher rates of short-term rental listings in Boston neighborhoods were linked to increased crime. Former Sedona city manager Justin Clifton told the Arizona Republic in 2019 that short-term rentals accounted for 20% of the city's entire housing stock. And so, we really need to be thinking about how this is affecting us. I mentioned also earlier, Scottsdale has over 4,000 short-term rentals within their city. Generally speaking, it's thought that maybe not all of those are even registered with the city. And so 4,000 plus maybe in Scottsdale, plus. Another stat, Scottsdale police were called nearly 800 times to short-term rentals between July 1st, 2021 and June 1st, 2022. That's something to think about. Okay, let's switch over. I just want to mention, do not forget that there are 4 other laws in addition to the new rental legislation that are going to be going into effect this weekend. We have a great handout on the new legislation, which is going to be going into effect. The 4 other bills, just briefly, associations can no longer ban artificial grass in associations that allow regular grass or turf in their communities. There's some intricacies to that. You can still pass rules regarding, how much of the land can have artificial grass and it has to look nice, etc. But that's a law that you need to know about, and you'll see that in our handout. Also, there is a new law that talks about the ability of owners to peacefully assemble on common areas and expands the ability of owners to have political signs on their property regarding association issues when there's a ballot measure sent out. It's kind of an interesting law. I can't wait to see how that one unfolds starting this weekend. Also, first responder flags are now an approved flag that need to be allowed to be flown in an association, regardless of what your documents state. And lastly, there's a procedure now for terminating a condominium that's created after this new legislation goes into effect. Probably won't see that very often, but it's notable, and I think you should be aware of it. Okay, it is right now 12:03. I'm only 3 minutes over, which is good. We have a lot of questions today, which is awesome. Over 22. Just a quick recap before we get into the questions. We had over 104 live viewers today on Zoom, and many others were with us here on Facebook Live. So thanks everybody for being here. Our first question is from somebody who asked, in 2019, we added a 6-month minimum rental restriction to our rules and regulations. Is this valid for the HOA to enforce? I mean, I'd have to look at all of your documents, but probably not. It just depends on what your CC&Rs say. Maybe your CC&Rs have an open-ended provision in there that says that rentals are allowed and the board can pass rules regarding, minimum time periods, but I doubt it. The short answer would be it really needs to be in your CC&Rs in order for that to be enforceable. Maybe your CC&Rs allow you to pass rules specifically regarding minimum time period rentals, although I think that's a stretch. I doubt that's the case. But bottom line is this really needs to be in the CC&Rs, and the statute in 2016 specifically says that. Okay, next question. I submitted an architectural review form in April. I still have not had a response. What are my options? Okay, I know you were at my last presentation that I thought you asked a similar question too. Basically, what I would do is I would write back to the architectural committee and give them another copy of it. Hopefully you have a copy of it, and demand for a response. Say that I submitted this back in April. I haven't received a response yet. I'm asking please for a response, and give them a time period. If they don't respond within that time period, you can go to the Arizona Department of Real Estate, file a complaint. You can hire a lawyer to send them a letter. You should check your documents to see if it's automatically approved if they don't respond with that certain time period. I think all of these are good options, but just make more and more effort, write to them and ask them to make a decision on it and give them a HOAs so that they know and tell them what you're going to do if they don't respond. Okay, question 3. Upon homeowners' request for an association to provide records, is a fourplex unit association required to disclose records? Can you clarify? Okay, if you are a homeowners association like an HOA, planned community, or condominium association, you are required to provide records to your association members if they request those records. You have 10 business days to provide the records to them after they've been requested. You can charge 15 cents per page for any records that they want a copy of. There are some records that can be withheld from disclosure, but there's very few, frankly, that can be told. Some examples of documents that could be withheld would be like legal opinions from the association's attorney to the board, any litigation that's pending. We wouldn't be able to give any information regarding that settlement discussions or it's from the executive session. On the topic of the executive sessions, as a homeowner, you're not allowed to review the executive session meeting minutes. So that's something that you can't have. But basically, there's a lot of information, like 98% of the association's books and records you are able to see. So if a homeowner makes that request in writing and it's not a category that can be withheld, the association needs to get those records within 10 business days. Okay, next question. On number 4, at a recent board meeting, a homeowner suggested a plan to charge owners who rent their properties $100 per month fee based upon the belief that the owners who rent their properties don't take as good a care of their unit as an owner resident. The fee would be used to offset expenses incurred due to lack of care. Can an HOA charge a fee on this basis? So my short answer would be no. I think I talked a little bit on this in my presentation, but I think that would be discriminating against owner landlords. And I would not suggest doing that. It won't withstand a challenge. Next question, number 5. As treasurer for my board, how much should I report on at an open meeting? Really good question. So I've served as treasurer of my board as well. I think you should give just a quick overview at each regular board meeting of, how the association, how much money we have in our, checking account, in our savings account, in our reserve account, in any CDs, when those CDs might be expiring, and what the plan is. You should be analyzing or making statements. Like if you have money in banks, is the money spread out so that you're under the FDIC cap in every bank? You just make a very short statement, like I got that on my radar, making sure that we never get over the FDIC cap, where there wouldn't be insurance, FDIC insurance, we had over the limits that's insured. You should talk about the budget for sure. Like point out what I would do typically is I would say we're a little bit over budget on this and here's why, and we're a little bit under budget on this and here's why, and here's our plan to, make sure that everything evens out and we have enough money. Maybe you have litigation or something that's something you didn't plan for and you have way over budget on legal. Well, I think this case is close to settling or will be paid when we win the case. I just try to have some thought process analysis as to how we're going to make it till December. And do we have enough income coming in to pay our bills? Also, as treasurer, you should be getting an update on anything that may be happening that, might be a problem. Like let's say you got 5 owners that are delinquent. And that's, making a pretty hefty dent in the amount of income that's coming into the association and how that's being handled while we turn these files over to have a lien recorded with our attorney. And the attorney is pursuing these owners for the debt, etc. And so it really should just be 5 minutes, I would say, at the most. And you should just give an overview. This is how much money we have. Here's where the money is. We've got a CD that's expiring next week. Here's the plan on what we're going to do with that. Here's our budget. Here's what we're a little over. Here's what we're under. We're doing fine. And if there's a problem like delinquencies, talk a little bit about what you're doing. So it's pretty basic, just a financial overview. What you don't want to do is do like 30 minutes. Deep dive, too much information because that's too much. Your job as a treasurer is to give a short summary of what's going on. The board packet should have all the backup information, including a year-to-date budget, bank statements, everything, so that if the board member wants to do a deep dive, they certainly can. Or if they want to meet with you individually to ask questions, they certainly can. Okay, next question. Can the manager require a copy of the insurance policy on the unit if the contract only recommends insurance? And so I'm guessing that you're trying to get a unit owner to provide like contents insurance proof, or maybe you even have additional insurance requirements. Unless the CCNRs mandate that an owner has to provide you with that information, the manager can't require it. If it was in the CCNRs that all owners must provide this to the board, then yes, you can require it. But absent that, cannot. Question 7, how can we legally distinguish between tenants and roommates? One homeowner has 6 roommates in his home. That's a really good question. So, in theory, roommates pay rent. So I would send a letter to the owner, and they may also be over the occupancy limitations and be imposed by your city, town, or county. So you might want to check in too. But I would send a letter, have the board send a letter asking for information about, who's living in the property. Is there like a landlord-tenant relationship? And if so, you can ask for the names. We said just go through the categories of information, the names of the adults, their vehicle license plate numbers, and vehicle description. All of that information you can ask for from them. Okay, question number 8. Can you define tenant versus occupant? This is an interesting idea in terms of fees where we use the term tenant. Okay, so a tenant is going to be typically somebody who there's an exchange of money for them to live in the property. An occupant could be like a family member or a friend who's just hanging out there, staying there for a couple of weeks. Maybe, they're being allowed to stay there for free. Again, in this situation, you just need to reach out to the owner and ask for more information. Is this a tenant? And if so, you're required to provide us with this information. Now, if it's just a friend that's there, the owner can decline and say, listen, this is not a landlord-tenant type situation here it's a friend that I want to stay here. And under the CCNRs, I have a right to delegate use of my home to a friend if I want to. Next question, number 9. Who retains the $25 registration fee? The association or the property management company, if they are managing the registration process and monitoring it? Well, the association can charge $25 fee and $15 late fee if the tenant information is provided in 15 days. Now, who gets that money is really going to depend on what the management contract between the associations and the management company says. And so, the law says that the association can charge it. So if the association wants to take the $25, you certainly have the right under the law. But recognize that the management company may have negotiated a contract that says they get that money. So you have to look at that contract to determine the answer to that question. Next question, number 10. I'm an interested homeowner. Our HOA board just required that we sign up for online parking permits. If a guest is to stay past 10 p.m., we must pay a fee of $5 per each vehicle. For a party of 10, $50. Many owners are upset and think that we have to pay for a guest to stay past 10 p.m., but that we are required to create an account online with the business and provide vehicle and contact information for guests. As part of the agreement, we have to allow data collection to be multiple companies. Are there any laws that would prevent this? This is really weird. I've never heard of anything like this. At first glance, I think it's possibly not enforceable. It would need to be in CCNRs for sure if you were going to be charging for something like this. But again, this is just kind of out there. I don't think this is something that I would ever advise the client to do. And so you may want to it sounds like you're a homeowner, interested homeowner. You may want to raise this issue at the board and get your own attorney to send them a letter on this because it does not appear to be enforceable. But I don't have all the facts on it. So I'd have to see all the paperwork to definitively say, yeah, I don't think this can be done. But at first glance, this doesn't look good. Okay, next question, number 11. Which state law is it that the landlord is possibly responsible for criminal activity? Okay, so it's ARS 33-1806.01, I think it is, or L, provides that an owner of a rental property shall abate criminal activity as authorized in section 12-991. It's really specific in that they have to abate criminal activity. They're going to be held responsible if there's criminal activity going on in their property and they don't do anything to abate that criminal activity. Now, they're not going to be charged for criminal activity that the tenant was doing, but they are going to be charged potentially for not abating that criminal activity. Okay, next question. HOA board member says he's not renting, but his sister lives at the property. No rentals are allowed. The assessor's website doesn't show it's a rental. Is this legal? It probably is. Now, you'd have to find out, is the sister paying rent, or is she just truly living there for free? These are always tough calls whenever people have friends coming in to stay and, you don't have any information that shows otherwise. But let's say the sister goes to pool some Saturday and she talks to another owner there and says, oh, I'm so lucky. My brother's letting me live here and I only have to pay $500 a month. Well, then that sounds like a rental relationship to me, and that owner would have to rent. But again, it's hard to do those. Next question, number 13. As a board, how do we know if the landlords have insurance required by the city and or county? Really great question. It depends on how the cities and counties are going to write up, their ordinances and requirements pursuant to this new law that's going into effect on the 24th. So what I would suggest is that you reach out to the city, town, or county that you live in after this weekend and find out, are you going to require this proof of insurance pursuant to this new law, and how would we go about getting information? Now, remember, if the property is listed in an online portal like VRBO or some other online rental services, they probably get insurance through that. And you likely would be able to write a letter asking for copy of insurance as board. Okay, next question. Is month-to-month rental considered short-term? So I'm guessing typically what happens is, so short answer, probably yes, it is. Because you're just doing like a 30 day rental and it just kind of keeps getting renewed. But sometimes, it's been like a year lease, let's say 6 fires just going on month to month. I would be cautious and I wouldn't be in favor of you saying to somebody, like, let's say you have a minimum year rental period and somebody is extending their lease by just staying month to month. I don't think you can say that they're short-term rental in violation of your minimum rental period or something like that. So you want to just look at the facts of each matter and determine, whether this is a short-term rental or not. Question 15. We successfully passed a 30-day minimum rental in our revised CC&Rs. However, we still have owners who violate the rule. What are our enforcement options? Talked about that a little bit here today, right? So enforcement options would be, number 1, have the association send a letter to the owner regarding the violation. Number 2, fine the owner after giving notice and the opportunity to be heard. Hire an attorney to send a letter or do a phone call to the owner. Filing a lawsuit against the owner in Superior Court, going to the Department of Real Estate, Arizona Department of Real Estate, and filing an administrative complaint to be heard by an administrative law judge against the owner. Those are all different ways to rectify this problem. Obviously, like I said earlier in this presentation, if you want to make it hurt for the landlord, make it hurt in their pocketbook. Big fines, attorney's fees, and potentially having to pursue a lawsuit. Okay, next question. Let's see, number 16. Can an HOA change CC&Rs to prevent any new homeowners from renting their units? So I think kind of what you're thinking on this is, okay, we're going to grandfather everybody who lives in the association, and we're going to pass an amendment that says any new owner who purchases after this date, probably it's going to be the date that the new CC&Rs get recorded, can no longer rent. It's possible that that's something that you definitely can do. We have to look at whether you look condominium or a planned community, but that is kind of a creative way to stand any legal challenges because whoever's buying, they know what they're getting into. They see right there and they get the CC&Rs disclosed to them as part of the disclosure statement, hey, no rentals. You may get pushback from small owners though, because they want to have options when they sell their property. And if they think that they can only sell to owners who are going to be owner occupied, it could limit their pool of people that would be willing to buy. Just a couple thoughts. I think that's helpful to get you pointed in the right direction. Okay, 9 more questions. Number 17, how does the recent Arizona Supreme Court ruling impact CC&R amendments? Really good question. So there's a recent case that was decided by the Arizona Supreme Court that seems to limit the ability of associations to pass amendments that aren't foreseeable to the membership or the owners. I really think I thought a lot about this. And if you look at, what the 2016 legislature did, they basically, through statutory changes, they told us if you want to implement minimum or you want to implement rental restrictions, you have to make an amendment to your CC&Rs. And so I think the way to argue this, if you want to implement changes to somehow regulate rentals or eliminate rentals, you're going to want to rely on that statute and say, this is what the legislature told us to do. And I don't have an answer because there hasn't been a case yet where this has actually been decided by an appellate court. But my inclination is, and I'm pretty conservative on these things, is that this would withstand a legal challenge if we could argue that, hey, the legislature told us this is what we do if we want to implement this. And that being said, too, prior to 2016, we didn't really need this. It wasn't foreseeable that this could happen because all of this was handled, the rental part of it was handled through ordinances and cities. So we're still doing rental restriction amendments. We're helping clients with rental restriction amendments and rental prohibition in associations. We do mention the risk with the new lawsuit that there could be a challenge to it, but we're writing it in such a way we think will withstand any challenge that could be made. Okay, next question. Can an HOA restrict commercial vehicles? Yes, it would need to be in your CC&Rs. In order to do that, there's a couple little exceptions for emergency vehicles under state law. So you would want to become familiar with that. If it's an emergency responder that needs a vehicle at home, they would probably be a loophole or exclusion to any amendment that you would do on that. But generally speaking, yes. Okay, next question, number 19. We have several rentals that are not part of our HOA, but within our subdivision from a builder. We allow use of our common areas, such as the pool, with a small fee paid to us. Can we ask that they follow the rules and regulations? For example, pet must be under 40 pounds. If your rules say that, and you're saying they're not part of your HOA, but you're allowing them to use the pool with a small fee. Well, if you're allowing them to use your pool, then of course you can tell them that we have rules at the pool and you can't do this. So it's enforceable. Question 20, in planning limits on the total number of rental units in a community, does that require an amendment to the CC&Rs or can it be changed by a majority vote of the board? So this association wants to put a limit on how many rentals there can be in an association, like only 20% of the units can be rented or something like that. That definitely need to put in the CC&Rs as a CC&R amendment, and that's not something that can be changed just by a majority of the board. Okay, next question, question 21. And let's see, what if the HOA or condo community is allowing some owners to say they are just friends and relatives staying at your condo, and that the community should not be concerned when they see people coming and going? Our rules require a 30-day minimum rental, but may not be enforced on some units because they say that they're friends. We talked about this a couple times now in the questions. These are hard to prove. I would ask the owner to document who's coming in and out so the association is aware of who's coming into the property and, who's authorized to be there and who's not. If this is a frequent thing, gently remind them of whatever rental restriction policies you may have in place. But unless you have any evidence that they are actually exchanging money, it's going to be hard to prove that using it as a short-term rental. Okay, next question. Is there a definition for a short-term rental? Yes. If you go to, there was a statute recently, Senate Bill 1168, that talks about vacation rentals and short-term rentals, look that up online. Just go to the Arizona Legislature's webpage and Google that, Arizona Legislature, type in Senate Bill 1168 in the search engine. You get to that page. And there's a section that gives a definition of a vacation rental or a short-term rental. Just generally speaking, it means any individually or collectively owned single-family or 1 to 4 family house or dwelling unit or any unit or group of units or the condominium or cooperative that is also a transient public lodging establishment or owner-occupied residential home offered for transient use if the accommodations are not classified in property taxation under Section 12001. This does not include a unit that is used for any non-residential use, including retail, restaurant, banquet space, event center, and other similar use. Okay, we're getting down to the end. We're down to our last 5 questions. This question is, a couple bought a home in our townhome community. Our understanding is when they complete renovating it, they plan to use it as an Airbnb. Our CC&Rs prohibit any resident from running a business of any type within their home. They said that they were going to put their property into an LLC. They will not be living in the home. Would that be considered running a business from that home? Interestingly, no, it's not. The business restrictions in your CC&Rs, unfortunately, do not extend over to rentals and rental properties. So if you want to restrict short-term rentals in your community to stop something like this from happening, you would need to do an amendment to your CC&Rs. Okay, last 4 questions. When Arizona legislature passes new laws, do they print amendments to the existing laws? Yes, they do. So starting after the 24th, you can go to the Arizona legislature's webpage, and the new changes should be implemented when you look at the listing of the codified new laws. Next question, 25. Our legal counsel has advised us in the context of the Arizona Supreme decision of Cowley versus Calabria Ranch, which is the case we've been talking about here today, that puts some limitations on amending CC&Rs, that our lawyer has told us that we halt our efforts to pursue amendments to our CC&Rs to restrict vacation and short-term rentals, pending further clarification by the legislature or the courts. In that light, do you recommend that we at least implement HOA monitoring and management of short-term rentals per the recent legislation? We currently have no established HOA practice to track or manage vacation or short-term rentals by our community management committee. Okay, so as I stated previously, we are not telling clients to stop passing amendments to CC&Rs based upon the Cowley case. What we are telling them is be cautious. Let's think it through. Let's have a strategy about how we structure the amendments. And so I'm going to respectfully disagree with what your legal counsel is saying. Do I recommend that you start monitoring how many you have in your community? Of course, you should be keeping an owner list, and under the law, you're required to. And if you want to make a notation that, hey, this is a rental property and this is not a rental property, you certainly have the right to do that. It's useful information for when you do ultimately decide to do an amendment. You need to know how many properties you have in your community that are rentals versus rentals. And something to think about is the longer you wait, the harder it's going to be for you to get those votes to implement that short-term rental amendment. So really think that through, because it can take years for the legislature, for the court system to have another case ripe and have a decision to better clarify that Cowley case. Okay, next question, number 26. The new law regarding political and first responder signs and flags seems to allow on the owner's property, in that we have a patio home condominium community and the association apparently owns everything, such as front lawns, but inside the unit walls, can the association still restrict display other than, say, inside? Okay, so the first responder flags or the other United States flag, the first responder flag is just kind of like an extension of the existing flag law that says that owners should be allowed to fly American flag, armed services flags. And now it's extended to first responder flags. So if you live in a condo, where can you fly them? You put them for the inside of it. Nope. The one way you could hang from your limited common elements, typically it is okay. What you can't do is put it on the common areas. Okay, next question. What if the renter was renting before the HOA changed the CC&Rs to require a minimum of 30 days rental? Can they be grandfathered in? Maybe that's a good question. I'd have to know more. So if the renter was already renting before the HOA changed, I don't know if I was renting previously. So maybe they come every March to Arizona and rent your condo. And it depends on how the amendment is structured. Does the amendment say that effective this date, there has to be a minimum 30-day rentals? Did it grandfather existing owners? I don't know information, but it sounds to me like any new rentals that are amended, that are created after the amendment, would have to be a minimum 30-day rental. Now, if the owner is using like an online platform and they booked out months in advance, the association potentially could have a legal problem because now that owner is breaking contracts. So talk to your attorney about this and come up with a plan that's going to be for everybody. You may have to allow the owner commitments within 30 days so that you don't get sued by the owner. But then any ones after those commitments would not be allowed. I think that's it. Got through all our questions. 27 questions, an hour and 3 minutes presentation on rental restrictions. We got it done today. Covered a lot of information. So thanks so much for hanging in there and being there with us today. We have a lot of learning opportunities coming up. And so we want to make sure that you're aware of that. First things first, we had 104 live viewers here today on Zoom, and many others joined us on Facebook Live. So thanks so much for being here today and sharing about your communities and wanting to learn more about this important topic. Our virtual First Friday free call-in is going to be Friday, October 7th at 9 a.m. And this is an opportunity for anybody to join us on Zoom or Facebook Live and ask one question for free. It's just a great opportunity for board members or homeowners to reach out and ask a question about HOA or condo law that you don't know the answer to and to try to stump. And so we're going to be doing that again. It's always the first Friday of every month, and you can join us on Facebook Live. If you can't be here live with us today, just so you know, we have all of our classes that we teach virtually. You can go back and listen to them on our website. Just go to mulcahylawfirm.com and go to our videos, our seminars tab, and you'll see upcoming classes listed on our seminars tab, and see the classes that are taught. The video replays can be one click away from hearing that class again. So just in conclusion, I want to wish everybody a happy fall first. And also I want to thank our really wonderful partners, all the different cities, towns, municipalities that are joining with us to provide this free education to homeowners, managers, and board members. So special shout out to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for having the vision to put these classes together to provide this free information to people who want to make their communities better. So have a great rest of the month, everybody, and I look forward to seeing you again in October. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.